Recently, you have been elected to the City Council, but not yet commenced office, many of you. At a holiday party, Joe, a high school classmate, neighbor, and longtime community activist, speaks to you of his strong opposition to Walmart's pending permit application to construct a store on the outskirts of town, far from the central business district. The permit will require City Council approval. After you take office, the Walmart permit comes before the Council. May you participate in the Council's proceedings? Does it matter that you did not tell Joe what your position was? Again, these questions are on the screen. Does it matter that your campaign materials spoke in opposition to the Walmart permit application? Joe also contributed $50 to your campaign. Does that influence your decision to remain for the Council's considerations? You also received $50 from the property owner hoping to sell to Walmart. Does that make a difference? So in your smaller groups at the satellite offices, let's take about 5-6 minutes and talk about this particular issue, and we'll get back together about a few minutes before 2 o'clock. Thank you. We are moving into the third part of our program. We talked about sources of authority. We talked in the last few sessions about how things get done and the manner in which we have to conduct business subject to the Open Public Meetings Act and the Public Records Act. We'll now be talking about the conflicts and ethics issues that you face as a council member in your communities. There are a number of bases for disqualification of you as a council member. We are going to talk a lot about one particular basis because it is the most common. But even though we may not talk about it, just as a reminder that you can be disqualified for actual bias, for prejudice, for prejudgment, as well as what we are going to talk about, violation of the Appearance of Fairness Doctrine. This doctrine, the Appearance of Fairness Doctrine, was unknown in the United States until 1969. The case arose out of Skagit County, where there had been an application for an aluminum plant on Guaymas Island. And the matter had gone through hearings before the Skagit County Planning Commission and ultimately to hearing before the Skagit County Commissioners. The Skagit County Commissioners closed the public hearing, recessed to deliberate on this issue, then, having questions, apparently, asked to see the applicants for the project permit. The developers, the applicant, went into the meeting with the county commissioners. Something went on, we don't know, it was not recorded, then left. Sometime after that, the commissioners came out and voted to approve the application with additional conditions and standards. You could probably speculate about what went on in that meeting. Commissioner said, well, if we get this, if we get that, if you do this, then we might approve it. They approved it, and the opponents to the project took it up to the Supreme Court. And the state Supreme Court looked at the conduct of a city council and a county council, county commission in this case, same standard, and said, when you as a council are engaged in quasi-judicial conduct, judge-like conduct, you are subject to the same standards that a judge would be subject to. And just as a judge can't talk to one party without having the other party present, You as a council should not be talking to one party with the other party not knowing what's going on. And ruled, again, first time in United States history about the application of the appearance of fairness doctrine. Not only must your conduct be fair, actually, but also appear to a disinterested person to be fair. And it was not to a disinterested person fair for the county commissioners in Skagit County to meet separately with these developers after the public hearing. The appearance of fairness doctrine caused all sorts of issues. One of the more dramatic ones occurred in Tacoma, where a city council member voted on a rezone of a land area over by the Tacoma Narrows, close to Tacoma Community College, for a big new apartment development. Upzone the property from single-family residential to multifamily. And it went through the full process. Public hearings went before the council, and the vote was to approve the rezone. The council member was a bank manager for Rainier Bank at some South Tacoma branch. Unknown to this council member, a Rainier Bank branch office in Seattle had made a preliminary loan commitment to construct that apartment building on that ground following rezone. Because the bank manager was a Rainier Bank officer, the court found that to be a sufficient basis to apply the appearance of fairness doctrine and overturn the Tacoma City Council's rezone decision. As a result of that and a number of other cases, the legislature stepped in and adopted Chapter 4236 RCW, and it's discussed at pages 14 and 15 of the Knowing the Territory book. And you can look at it in time. But it specifically addressed some of the problems that were raised in the earlier questions, such as what happens if you receive campaign contributions? Does that affect your ability to make a decision? So if you took a campaign contribution from your buddy, he's known to be opposed to the Walmart decision, is that a violation of the appearance of fairness doctrine? No, it's not. The law says also that whatever you say in a campaign cannot be a basis for a violation of the appearance of fairness doctrine. But I caution you, what you say in a campaign may not be a violation of the appearance of fairness doctrine, but it could be used as evidence of actual bias. If in your campaign you say something to the extent of, over my dead body will I ever permit Walmart to be built in this city, then have you demonstrated actual bias such that when it comes before you, you won't be able to make a disinterested, unbiased decision. So be careful about that. Isn't it the job of a council member to listen to all sides and give as much information as you can to make a decision before you make a decision? In some cases, yes, but in some cases, no. When you're dealing as a legislator, when you're working on general issues for the community, setting a speed limit on a city street, deciding what the overall comprehensive plan of the city should be, you are acting in a legislative capacity, and you can make your decision on any basis you want. You can talk to the Sierra Club, or you can talk to the Chamber of Commerce. You can talk to any interest group you want. You can talk to your next door neighbor. It doesn't matter. The law doesn't restrict you in your considerations. But when you're involved in judge-like, quasi-judicial proceedings, the law says you must only make your decision based upon the evidence before you. I'm again going to pick on a county because they just provide me with lots of good information to use when I lecture to cities. This case involves an application by the Maranatha Company for a gravel extraction permit in rural Pierce County. Gravel mine, gravel pit, if you will. And I'm just going to read from you a portion of the court's decision in that case. The county council reviewed the examiner, the hearing, let me set this up, I apologize. Maranatha made its application. It went to the hearing examiner after staff review. The hearing examiner reviewed it, conducted a public hearing, said there are unanswered questions about potential impacts of this project, sent it back to the staff for further work. The case came back to the hearing examiner, conducted another full hearing, and then issued a report approving the permit application. The neighbors opposed to this gravel pit appealed to the Pierce County Council, and the Pierce County Council conducted a further hearing on the application to the court decision. The attorney for a group of opponents commented that perhaps it would take, quote, take a fatality between a gravel truck and a school bus before the council would deny the permit. Occasionally, the audience interrupted the proceedings with emotional outbursts concerning the safety of school children and the degree to which the project would diminish the quality of life of area residents. Finally, one of the council members spoke out about her knowledge of the site, her personal feelings that the permit application should be denied, and her concerns about Maranatha's ability to comply with the conditions. The council denied the permit. The court said, it is apparent that the council gave little consideration to the merits of Maranatha's application, and that it disregarded the facts set forth in the examiner's findings. The council seems to have heard clearly the citizen complaints and the comments of one of its own members while disregarding the record. We cannot escape the conclusion, in view of the evidence in support of Maranatha's application, that the council based its decision on community displeasure and not on reasons backed by the policies and standards as the law requires. The court went on to say, further, if there's concerns about the permit conditions associated with the project, they should be monitored, and if they don't comply with the permit, then you lift the permit. When you permit is when the project's conditioned, you cannot assume that the conditions will not be met. And there's the citation to that 1990 decision. A similar case came out of Spokane in the late 90s. And this is a very good example not only of a council overstepping its quasi-judicial role, but also its role as legislators and not administrators. Mission Springs Company had, over a series of years, gone through the permitting process to construct a large apartment complex. The grading permit had been issued, but then suspended and then reissued, or it was about to be reissued for the project as a result of some delays that had nothing to do with the city. And the Maranatha company, or the Mission Springs Company, began to assemble its equipment at the site in preparation for the permit issuance. The staff at the city council meeting, Spokane City Council meeting, was giving a report. This is happening, that's happening, and the grading permit is about to issue on the Mission Springs project. The neighbors, seeing all this activity, had called their council members, and the council members said, wait a second, we haven't heard about this, and we want to put a stop to this. And there is a long, lengthy debate, and it's on the public record. It's quoted in the Supreme Court decision. The city attorney told the city council it had no authority to do this. Here's what one of the council members said. You know, I guess I would add that, you know, with all due respect, I think we owe an obligation to the other members of the community who have serious concerns about the traffic problems up in that area. I guess, too, my feeling is, and I think this is a great motion, we have an opportunity to put a stop to this, and let's just see what happens. Let's see how confident they are. If they bring a suit, we can always turn around and issue the permit. That's still an option available to us. Council ordered the city manager, Spokane at the time was a manager-council form of government, not to issue the permit. And, of course, Mission Springs sued. 3 or 4 months later, the council finally, realized that they were going to be really beat up on this issue and issued the permit. But what had happened? In Spokane, they lost the entire construction season. because by the time the permit issued late in the fall of that year, they couldn't construct. The ground's frozen, nothing can go forward, and they lost an entire year. And they lost a lot of money in that case as a result of the council acting outside of its authority. And the court said legislative immunity is not available to the individual council members. Individual council members who voted to direct the city manager to not issue the permit were named in the lawsuit in their individual capacity, subjecting their personal wealth, their personal holdings to liability. The city eventually settled with the developer, paying a lot of money on behalf of the city and of the elected officials. The court said we have a straightforward situation where clear legal rights of the citizen were violated by city council members acting in excess of their lawful authority and by a city manager acting in excess of his own lawful authority, but at the urging of the city council. Here's a headline from the Seattle PI back in 2005. Burien slapped with $10.5 million verdict. The evidence in this case is reported to have shown that city council members directed staff or influenced staff to delay permitting of an apartment complex in the city of Burien. This report was in 2005 after the jury returned the verdict against the city. The Court of Appeals later affirmed that verdict about a year and a half later. Again, the council acting outside of its authority and subjecting the city to liability. So the question that you should face as a trustee for the city, because you do hold a trust responsibility in your position as an officer of this municipal corporation. In your trust responsibility, is your trust better carried out by listening to the public, your neighbors, or protecting the city from this kind of liability? And I'm just telling you that our courts will tell you time and time again that when you're acting in a judge-like capacity, you must base your decision on the facts and evidence before you and not on some community opposition. Where do you address community opposition? You do that in your comprehensive plan and zoning code. If this property was not appropriate for an apartment building, then amend your zoning code and say so. Don't make these decisions on an ad hoc basis based upon a permit that's filed. At some point, you as a city had made a determination regarding the lawful use of property in this particular zone. By not following that policy and direction, you may be violating the law. So as Sergeant Esther Hazy said on that old Hill Street Blues television show, be careful out there.